blow me away. Don't become a speechwriter if this law thing doesn't work out, because these speeches really throw a wrinkle into everything. And that's what we're trying to figure out. Who are we getting here? You know, who are we getting as a nation? Now, legal realism, are you familiar with that term?
I am.
What does it mean for someone who may be watching the hearing?
To me, it means that you are guided in reaching decisions in law by the realism of the situation, of it's less, it looks at the law through the...
It's kind of touchy-feely stuff.
It's not quite words that I would use, because there are many academics and judges who have talked about being legal realists. I don't apply that label to myself at all. As I said, I look at law and precedent and discern its principles and apply it to the situation.
So you would not be a disciple of the legal realism school?
No.
Okay. All right. Would you be considered a strict constructionist in your own mind?
I don't use labels to describe what I do. There's been much discussion today about what various labels mean and don't mean. Each person uses those labels and gives it their own sense of
when Judge Rehnquist says he was a strict constructionist, did you know what he was talking about?
I think I understood what he was referencing, but his use is not how I go about looking at...
What does strict constructionism mean to you?
Well, it means that you look at the Constitution as it's written, or statutes as they're written, and you apply them exactly by the words.
Right. Would you be an originalist?
Again, I don't use labels.
Okay.
And because...
What is an originalist?
In my understanding, an originalist is someone who looks at what the founding fathers intended and what the situation confronting them was, and you use that to determine every situation presented, not every, but most situations presented by the Constitution.
Do you believe the Constitution is a living, breathing, evolving document?
The Constitution is a document that is immutable to the sense that it's lasted 200 years. The Constitution has not changed except by amendment. It is a process, the amendment process, that is set forth in the document. It doesn't live other than to be timeless by the expression of what it says. What changes is society. What changes is what facts a judge may get presented.
What's the best way for society to change, generally speaking? What's the most legitimate way for society to change?
I don't know if I can use the words change. Society changes because there's been new developments in technology, medicine, in society growing.
Do you think judges have changed society by some of the landmark decisions in the last 40 years?
Well, in the last few years?
40 years.
I'm sorry, you said the...
40, I'm sorry, 40, 40. Do you think Roe v. Wade changed American society?
Roe versus Wade looked at the Constitution and decided that the Constitution, as applied to a claimed right, applied.
Is there anything in the Constitution that says a state legislator or the Congress cannot regulate abortion or the definition of life in the first trimester?
The holding of the court as...
I'm asking the Constitution. Does the Constitution as written prohibit a legislative body at the state or federal level from defining life or regulating the rights of the unborn or protecting the rights of the unborn in the first trimester?
The Constitution in the 14th Amendment has a
I'm sorry, is there anything in the document written about abortion?
The word abortion is not used in the Constitution, but the Constitution does have a broad provision concerning a liberty provision under the due process.
And that gets us to the speeches. That broad provision of the Constitution has taken us from no written prohibition protecting the unborn, no written statement that you can't voluntarily pray in school, and on and on and on and on. And that's what drives us here, quite frankly. That's my concern. And when we talk about balls and strikes, maybe that's not the right way to talk about it, but a lot of us feel that the best way to change society is to go to the ballot box, elect someone, and if they're not doing it right, get rid of them through the electoral process. And a lot of us are concerned, from the left and the right, that unelected judges are very quick to change society in a way that's disturbing. Can you understand how people may feel that way?
Certainly, sir.
Okay. Now, let's talk about you. I like you, by the way, for whatever that matters. Since I may vote for you, that ought to matter to you. One thing that stood out about your record is that when you look at the almanac of the federal judiciary, lawyers anonymously rate judges in terms of temperament. And here's what they said about you. She's a terror on the bench. She's temperamental, excitable, she seems angry. She's overly aggressive, not very judicial. She does not have a very good temperament. She abuses lawyers. She really lacks judicial temperament. She behaves in an out-of-control manner. She makes inappropriate outbursts. She is nasty to lawyers. She will attack lawyers for making an argument she does not like. She can be a bit of a bully. When you look at the evaluation of the judges on the Second Circuit, you stand out like a sore thumb in terms of your temperament. What is your answer to these criticisms?
I do ask tough questions at oral argument.
Are you the only one that asks tough questions in oral argument?
No, not at all. I can only explain what I'm doing, which is when I ask lawyers tough questions, it's to give them an opportunity to explain their positions on both sides and to persuade me that they're right. I do know that in the Second Circuit, because we only give litigants 10 minutes of oral argument each, that the processes in the Second Circuit are different than in most other circuits across the country. And that some lawyers do find that our court, which is not just me, but our court generally is described as a hot bench. It's a term of art lawyers use. It means that they're peppered with questions. Lots of lawyers who are unfamiliar with the process in the Second Circuit find that tough bench difficult and challenging.
If I may interject, Judge, they find you difficult and challenging more than your colleagues. And the only reason I mention this is that it stands out when you know, there are many positive things about you, and these hearings are designed to talk about the good and the bad. And I never liked appearing before a judge that I thought was a bully. It's hard enough being a lawyer, having your client there to begin with without the judge just beating you up for no good reason. Do you think you have a temperament problem?
No, sir. I can only talk about what I know about my relationship with the judges of my court and with the lawyers who appear regularly from our circuit. And I believe that my reputation is such that I ask the hard questions, but I do it evenly for both sides.
In fairness to you, there are plenty of statements in the record in support of you as a person that do not go down this line. But I would just suggest to you, for what it's worth, Judge, as you go forward here, that these statements about you are striking. They're not about your colleagues. You know, the 10-minute rule applies to everybody, and that, you know, obviously you've accomplished a lot in your life, but maybe these hearings are time for self-reflection. This is pretty tough stuff that you don't see from about other judges on the Second Circuit.
That was part of Judge